YouTube. We're actually going to have it today. All right. In keeping up with the spirit of the open courts provision of the Texas Constitution, this hearing is being broadcast live on YouTube. After the hearing is concluded, it will be marked private. I will note that anybody who might be watching, although I don't see anybody watching yet, that recording of this hearing is absolutely prohibited. Rebroadcast of this hearing is absolutely prohibited. Violation of this order will subject the broadcaster or recorder to civil and or criminal contempt. All right, Mr. Hood, we're here on a motion to modify, okay? Previously gone over with you your right to have this hearing before Judge Kim. You stated that you wish to have it in front of me. We've already determined that you are under 18 years of age. And we're here on the motion to modify that was filed April 20th of this year. Now, Mr. Hood, you have an absolute right to remain silent and not say anything at all unless that's what you want to do. Unless I'm the one who's asking you a question, or if there's something you want to say, please do not blurt it out. Instead, what I want you to do is wave your hand like this, and I'll create that internet chat room for you and your attorney to talk about what you want to talk about. That way he can tell you whether or not you really should say it before you just blurt it out. Because unlike detention hearings, anything you say here today can be used against you, not just at this hearing, but any future hearing, even if you get into trouble as an adult. Do you understand that?
Okay.
And I don't want you to do anything that might hurt your rights either now or in the future. And that's why Mr. Adeniji would like you to remain silent unless he advises you to talk, okay?
Yes, sir.
We had a little problem yesterday with one of his clients who wanted to talk out of turn. And it could have been bad for his client. And I don't want you to be that, Mr. Hood, okay?
Okay.
All right. Now, you were placed on probation by this court. Let me go back, find the judgment real quick. You were placed on probation back in February 4th of this year. Do you remember that?
Yes, sir.
In fact, it was in front of me, right?
Yes, sir.
All right. Now, as a condition of your probation, you were ordered to not violate any laws. Do you remember that?
Yes, sir.
You were also ordered to obey all the orders of the court. Do you remember that?
Yes, sir.
You were ordered not to associate with people or kids who are on probation or parole. Do you remember that?
Yes, sir.
That includes parole from the Texas Juvenile Justice Department. Do you understand that?
Yes, sir.
You were also ordered not to use or possess alcohol, marijuana, inhalants, or any other illegal substance or substances. And you were ordered to submit to random urinalysis. And it was as a condition of your probation, you were ordered to not test positive for any illegal or controlled substance. Do you understand that?
Okay.
Okay. Next, you were also ordered to attend school, right?
Yes, sir.
Okay. Before we go any further, is there an agreement among the parties regarding what should happen here?
Yes, Your Honor.
Yes, Your Honor.
All right. I'm not going to ask for the specifics of that agreement yet. All right. Mr. Hood, I have a very lengthy stipulation agreement. Because we can't do this hearing in person, we're doing it by Zoom meeting. The law requires me to read the entirety of the stipulation agreement to you, okay?
Yes, sir.
And at the end of it, well, actually, what I'm going to do is I'm going to go paragraph by paragraph and ask you individually for individual paragraphs whether you agree with that or not, okay?
Yes, sir.
And then at the very end, I'm going to ask you if you agree with the whole thing.
Yes, sir.
Then I'll also ask Ms. McGilvery if she agrees with the whole thing, but I'm not going to ask her on the paragraph by paragraph, okay?
Yes, sir.
All right. Now, because this is a motion to modify hearing, you have no right to a jury trial. Instead, I get to decide everything. You understand that?
Yes, sir.
Now, if there's an agreement between you and your attorney and the prosecutor regarding what should happen here, and if I follow that agreement, you give up one more very important right. We call that the right of appeal. We talked about that previously at your earlier hearing, right?
Yes, sir.
That's where a different court in downtown Fort Worth would look at what we do here today to make sure what we do was done correctly. But if there's a plea agreement, and if I follow it, there won't be any appeal. You got that?
Yes, sir.
Now, if for some reason I do not follow the plea agreement, then this stipulation agreement, I'm going to go over with you. I'll rip it up. And I'll actually go through and I'll make sure that this hearing that we're doing right now doesn't count against you, okay?
Yes, sir.
But that's only if I don't follow the plea agreement, okay?
Mhm.
All right, here's the stipulation agreement. Cause number 323-112019-19 in the matter of Braden Marquise Hood in the 323rd District Court of Tarrant County, Texas. Stipulation agreement to the Honorable Judge of said court. May it be agreed and stipulated between the parties in the above, it says styles, it should be styled, and numbered cause in which Braden Marquise Hood is the respondent, the following facts. Okay, paragraph 1. If the witness, Sparkle McGilvery, were in court and testified under oath, she would testify that they reside at 508 Macquarie Street, Arlington, Tarrant County, Texas. They would further testify that Ms. McGilvery is the parent or guardian of the respondent, that's you, in this cause, that the respondent's name is Braden Marquise Hood, a male child, 16 years of age, having been born on, and I'm not going to repeat for the world what your birthday did, but we've already discussed your birthday, right?
Okay.
Okay. The witness would also testify that they are the person who has custody and control of the respondent in this case. All right. Is the entirety of that paragraph true?
Yes, sir.
And you agree with it?
Yes, sir.
Okay, next paragraph. I, Braden Marquise Hood, the respondent in the above entitled and numbered cause in writing in an open court, consent to this stipulation of evidence, and in so doing expressly waive the appearance, confrontation, and cross-examination of witnesses, the right to a trial, and the right to a trial by jury. And it says that even though you don't have a right to trial by jury, you understand that?
Yes, sir.
And you further consent to the introduction of testimony by affidavits, written statements of witnesses, and other documentary evidence. Accordingly, having waived my federal and state constitutional right against self-incrimination, and having been sworn upon oath, I judicially confess to the following facts and agree and stipulate that the facts are true and correct and constitute the evidence in this case. Then I'm going to read a whole bunch of stuff to you, okay?
Yes, sir.
Essentially, if you agree with that paragraph, you're giving up your right to remain silent. You understand that?
Yes, sir.
You're giving up your right to force the prosecutor to call in all the witnesses who might testify against you. You understand that?
Yes, sir.
You're giving up the right to be in the same courtroom as them, to look them in the eye. Do you understand that?
Yes, sir.
And you're also giving up the right to have your attorney cross-examine them to make sure they're telling the truth. You understand that?
Yes, sir.
Okay, here we go. Here are the important facts. First, you were born on, and I'm not going to read the date of birth, but we already talked about your date of birth, and it's the same date of birth you gave me earlier, and it says you live in Tarrant County, Texas. Is that true?
Yes, sir.
All right. You were placed on probation in this case for the felony offense of harassment by person in a correctional detention or civil commitment facility on November 5th, 2019.
Yes, sir.
Okay. I agree and stipulate that the court gave me certain terms and rules for the probation period that included the following. First, the respondent was ordered not to violate any laws. Was that a condition of your probation?
Yes, sir.
Respondent was ordered to obey all orders of the court. Was that a condition of your probation?
Yes, sir.
Respondent was ordered not to associate with others on probation or parole. Was that a condition of your probation?
Yes, sir.
Respondent was ordered not to use or possess alcohol, marijuana, inhalants, or any other illegal substance. Respondent was ordered to submit to random urinalysis. Respondent was ordered not, it should be not test positive for any illegal or controlled substance. Was that a condition of your probation?
Yes, sir.
And finally, respondent was ordered to attend school, whether public, private, or vocational, every day it was in session. Respondent was ordered to obey all school rules and regulations. Respondent was ordered to be regular in attendance, diligent in studies, punctual in reporting for classes. If for any reason respondent was not allowed to attend school, respondent was ordered to remain home during school hours unless other arrangements have been approved by respondent's probation officer. Was that a condition of your probation?
Yes, sir.
You had to go to school, right?
Yes, sir.
I think I specifically remember talking to you about that, right?
Yes, sir.
Okay. Further, you agree and you stipulated that you violated your probation by paragraph 1. On or about April 14th, 2020, you tested positive for one or more illegal or controlled substances. Mr. Hood, is that allegation true or not true?
It's true.
Paragraph 2. On or about April 13th, 2020, you committed the offense of theft of property valued at $100 or more, but less than $750. Is that allegation true or not true?
It's true.
Paragraph 3. On or about April 13th, 2020, you associated with Quincy Redrick, a juvenile on probation. Is that allegation true or not true?
It's true.
Paragraph 4. On or about March 5th, 2020, you tested positive for one or more illegal or controlled substances. Is that allegation true or not true?
It's true.
Paragraph 5. On or about February 26, 2020, you were not in school while school was in session.
It's
Is
true.
that allegation true or not true?
It's true.
All right. Has anybody forced you to come in here and plead true to those 5 paragraphs?
No, sir.
Anybody tricked you into doing it?
No, sir.
Anybody promised you $1 million if you come in here
No, sir.
and plead true?
No, sir.
Are you telling me the only reasons you're pleading true is A, because it is true, and B, because that's what you want to do?
Yes, sir.
Now, do you understand that because this is a motion to modify probation and you're on probation for a felony, I got a whole big range of options open to me. Option number 1, even though you just pleaded true, I could find none of it true. Release you from detention today, you go back home with your mom and you continue on probation as you've been. That's option number 1. Option number 2, I could still find everything true, but do nothing, make no changes at all, right? Option number 3, I could find it all true and add more conditions to your probation, including sending you to Iowa or Michigan or Arizona to a school out there to get help, to let you get help, get treatment, and hopefully get you rehabilitated. You understand?
Yes, sir.
The 4th option, most serious option. I could find all this true. What do you think that most serious option is?
TJD.
That's correct. All right. So you understand, I got this big range here, right?
Yes, sir.
Now, knowing I've got all that range and knowing, though, that there's a plea agreement with you and the state regarding what should happen here, do you still wish to proceed? I'll give you one more chance to withdraw all your pleas of true, and we'll go back to 0, or we can go forward. What do you want to do?
I want to go forward.
Okay. Final paragraph. I, Braden Marquise Hood, further agree and stipulate that I am a child in need of rehabilitation, or that the protection of the public requires that disposition be made. I further agree to a disposition of probation until your 18th birthday. Further, to complete a drug assessment and participate in any recommended treatment, including inpatient services at the Youth Recovery Campus. Participate in and complete the FIT program after treatment or placement, wear an electronic monitor, and any other reasonable conditions imposed by the court. All right. Do you agree with that paragraph?
Yes, sir. Oh, well, I got a question.
Fire away.
Honestly, I don't think I need rehab. And I told my PO that, I told her I feel like, because when I had first got on probation, they gave me 6 months deferred and I was clean for the whole 6 months. So I told her that I feel like I can stay clean for the 18 months. I just,
Well,
Judge, can we step aside for a few minutes?
okay. Now, Mr. Hood, I'm going to send you to a breakout room to talk to your attorney, okay?
okay.
Hold on.
Do I click join? Hey, do I click join? Can I click it?
Okay. Mr. Adeniji, at the bottom of your screen, there should be a button that says either more or breakout room. You'll need to click on that and then go into the client counseling room. Mr. Hood, also, you need to do the same thing. Go down to the bottom of your screen and there should be something that says more or breakout room. You see it yet?
Oh, okay. Oh, there you go. I got it.
There you go. Ms. McGilvery, I don't want you to answer this question yet. I just want to let you know when they come back into the hearing, I will ask you if you agree with everything that I just read to Mr. Hood, and then I'll ask Mr. Hood if he finally agrees with everything, okay?
Okay.
All right. I don't want you to answer that question yet, though. All right.
Judge, we are back.
Pardon, Mr. Adeniji?
I said we are back.
Okay. Ms. McGilvery, you heard me read the stipulation to Mr. Hood. Do you agree with everything in the stipulation?
Yes.
All right. Mr. Hood, do you agree with everything in the stipulation?
Yes, sir.
And
Mr.
just to make sure, Judge, I've explained repeatedly to Mr. Hood, and he understands now that the chance he's taking being on probation is that he's giving up any of his rights, that he's not in control of anything again. It's whatever the probation officer directs him to do is the court order. And if he says no, he's coming right back. So he understands that now, Judge.
All right. That's important. Thank you, Mr. Adeniji. Okay. Then given that everybody has agreed to the stipulation agreement on the record, the court will sign it. Does either side believe there are any additional admonishments that need to be given to the respondent at this time?
No, Judge.
No, Your Honor.
All right, State, I will allow you to present your case.
Okay, State would offer petitioner's exhibit number 1, the social history.
Mr. Adeniji, have you had a chance to review the social history in advance?
I have reviewed the social history. I have no objection.
Do you know of any additions, corrections, or deletions that need to be made there too?
No, Judge.
All right. Petitioner's Exhibit 1, the social history, will be received and admitted into evidence. Who would the state call as its first witness?
They would call Cynthia Gonzalez.
All right, Ms. Gonzalez. Let me take you. There we go. Okay. You are participating in this hearing by Zoom meeting. I see you on the screen. Please raise your right hand. You solemnly swear or affirm that the testimony you will give in this cause will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes, Your Honor.
All right, State, before you proceed, Mr. Hood, can you see Ms. Gonzalez on the screen?
Yes, sir.
Okay, and Mr. Adeniji, can you see Ms. Gonzalez on the screen?
Yes, Your Honor.
All right, State, you may proceed.
Thank you, Judge. Ms. Gonzalez, how are you employed?
I'm currently a probation officer here for Tarrant County.
Okay. And are you the person who put together petitioner's exhibit number 1, the social history?
That's correct.
Okay, and Mr. Hood, he's your client.
That's correct.
Okay. I just want to briefly kind of go through the social history with you. Starting with his history here. Has he had contact with the department previous to today?
He has. He's actually been on probation for harassment by person as well as unauthorized use of a motor vehicle. He has been on my caseload since November the 6th of 2019.
On your caseload, other than these new recent violations that we have, how has he been doing?
Well, since he's been on probation for, I'd say, I guess May 6th would be about 6 months. He was doing initially, okay. He was referred in and his probation was modified once again back in February 4th of 2020 is when it was modified. And so he did well up until we went to court. And it did seem that right after February, for whatever reason, we started kind of having some of these incidents where we were kind of leaving, coming and going without permission. And then we were missing a lot of school. He's enrolled over at the Arlington High School. He was expelled from Lamar because of all the issues that were going on. And we thought that putting him over at Arlington High School was going to help. And like I said, it did initially before we went to court, and it seemed like right after court, we just started right back into our old routine. Trying to track him down was, at school or even because at the time he was living with his grandmother because that's the area code, zip code where Arlington High School belonged. And so we were hoping that being at grandma, things were going to be a bit better. But unfortunately, the wheels kind of fell off. And he returned back to his mother's house shortly after spring break because her plan was to get him enrolled over at venture, I believe, in Arlington. And unfortunately, COVID-19 epidemic hit, and schools were closed down. And so he is enrolled in homeschool right now through Arlington ISD. I believe he's still enrolled at Arlington High School. However, we've had some issues with him consistently getting online and working on his schoolwork. He is very respectful with me. When I did catch him, at school, he was more than willing to take drug tests. Unfortunately, I believe the last one we had, he was positive for marijuana. And then unfortunately, I wasn't able to go back into the house with all the COVID-19 restrictions. And then he was referred back to our detention center, I believe it was April, when he tested positive for marijuana, amphetamines, and methamphetamines.
What are the programs specifically that he's had since he's been on probation?
Sure, absolutely. So he has been.
Are you there? Are you? Sorry, that's my phone.
Oh, okay. So he has participated with the family counseling program through Lena Pope Home Family Functioning Therapy, or FFT. It's my understanding that begun January the 15th, and it's still active. However, they are really not able to engage with him while he's in detention. But it's definitely a program that I believe he and mom were benefiting from. I'm sorry, and we're participating successfully. He has also been ordered several community service hours. His very first probation, I believe, they ordered him 80 hours, and that was the 5th, I believe, which he completed 18 of those, and he still owes 62 for that term of probation. And then the last time that he was in front of Judge Porter, he was ordered another 80, and I don't believe that he's begun working on those yet, unfortunately. He was in our drug court program, and it looks like it was from May the 23rd of 2018 until about, it looks like he completed it January the 15th of 2019. He has also been on electronic monitor and successfully completed that program as well.
Okay, and the recommendation of a drug assessment and then possibly inpatient TYRC, why is that your recommendation?
Seeing that he has had a history with our department, having started initially his history out here through the drug court program, and I agree, he did do well in the drug court program. However, it seems like here recently, I say probably as far as back as, I think March, we started seeing positive drug test results. And the most recent, which was April the 14th, and it wasn't just marijuana at that point. We're looking at amphetamines and methamphetamines, which is concerning to our department. And as you know, he has, we were not able to get him assessed while in detention just because of all the restrictions being placed back there. However, TWARS has agreed to assess him today, if that is the order of the court, to have him complete that. And so we recommend that he participate in that, he complete it honestly and truthfully, and just see, if he can, if he meets the qualifications for inpatient, then they have a bed available for him today.
Okay. And it's fair to say, when looking at his drug history in conjunction with him committing crimes, that it appears from this exhibit, Petitioner Exhibit 1, that it's the times that he's taking drugs, that he's on drugs, that he's also committing crimes in the community. Would you say that's fair?
That's what it, yes, that's correct.
Okay. And so this is just kind of another opportunity to keep him in the community here, but still help him receive those services.
Correct. Yes, because once he completes outpatient, I know they'll have an aftercare plan, but our hope is for him to complete it successfully and then go back home with mom. I know he's got, some community service hours to do. I think we're at 142 hours. And so it's my understanding that he could even work on those hours while he's at TORC as well.
Okay. And in addition to TYRC, and if he is inpatient there, is it your recommendation that he complete the FFT program?
Yes, I definitely would like to encourage him to do that, just because it's been working. It sounds like it's really had been helping build boundaries and helping communications, lines of communications between mom and Braden some. And it was going successfully. So I would like to see them complete that.
Okay. And in addition to that, do you think that it would be in his best interest to also be on an electronic monitor for as long as the court sees fit, as he's successfully completed it in the past?
Yeah, I think it'd be helpful to just initially get him back into the routine of getting back home once he's been successfully discharged from treatment, so that he, is available for outpatient sessions and available for his meetings with mom or his family counseling meetings, as well as maybe get a little bit more compliance with his schoolwork.
Okay, I'll pass the witness.
Hey, Mr. Adeniji.
Thank you, Judge. Cynthia, what's your impression of the problem that Braden is having, being in compliance with the terms? Does he have any psychological problems?
We have not completed a psych eval, so I don't know that I can answer that question.
And what I'm saying, do you have any impression that may be an issue?
That he has any psychological problems, you said?
Yes, ma'am.
Without proper assessment, I can't tell you, in all honesty, if he does or doesn't.
And what I'm trying to get at is, you have stated that in your dealings with him, it's always been very respectful.
That's correct.
And anytime you ask him for his UAs, and he doesn't give you a runaround.
That's correct. He's compliant when it comes to that. Mm-hmm.
Do you have any of his school records as to where exactly is he in terms of his school performance? I know you said he's skipping school, but do you have any records about how well he's doing or how well he's not doing?
Sure. I do have some school records. Those records would probably not be reflective of the most recent closures. So April, I don't have record for April because school was closed shortly after spring break. However, I do have records. I'd say probably from February, early February to mid March. And as well as, like I said, just accounts of me attempting to meet him at school on several occasions during the week. And, those were missed visits with us.
Okay. And since it's been in the detention, it's for the most part been level 1 outstanding?
He has gotten on level 1, I believe, as of yesterday. And there are no infractions or sanctions as far as I looked into the records this morning. It looks like there are no infractions and sanctions, but he did get on level 1 outstanding as of yesterday.
No further question, Judge.
Any redirect, Ms. Smith?
No, Your Honor.
May this witness be finally excused by both sides?
Yes, Your Honor.
Yes,
All
Your
right,
Honor.
who would the state call as its next witness?
The state would rest.
All right, Mr. Adeniji.
Yes, Judge. I'll call Brady Hood.
All right, now, Mr. Hood, your attorney's about to give you the opportunity to testify. You do not have to testify. The decision whether or not to do so is entirely your decision, okay? Now, based on our interactions already today and our interactions in the past, I'm going to go ahead without further qualification and make the finding that you understand the difference between a truth and a lie and that you are competent to testify in this matter. But you need to understand that If Mr. Adeniji asks you just one question and you give him just one answer, then the state will get the opportunity to ask you anything it wants. Okay? That's what we call cross-examination. So knowing that you are going to subject yourself to cross-examination, if you just answer one question, do you still wish to testify today?
Yes, sir.
All right, Mr. Adeniji, you may continue.
Thank you, Judge. Mr. Hood, you know you've had history with this department, don't you?
Sir?
You have history with the department.
Yes, sir.
How many times has the state decided to give you another chance?
You said how many times?
How many times has the state decided to give you another chance?
Twice.
No, maybe 3 times. Right?
Yes, sir.
You know the judge remembered you,
Yes, sir.
and he remembered the warnings he gave you the last time.
Yes, sir.
I just want to make sure you understand. If you come back again, you remember what the judge asked you earlier? What do you think is going to happen?
I'm gonna get sent off to TJJD.
At that point, will you say the state has not given you enough opportunity to be on the right track?
Yes, sir.
Will you say the state has not done the best for you to make sure you do the right thing?
Yes, sir.
Who will you have to blame if that happens?
Myself.
And you know your mom is on board, right?
Sir.
Your mom is frustrated,
Yes, sir.
and you know she is not supportive of your non-compliance.
Yes, sir.
So you are telling the judge today what?
Yeah, that I can get right. If whatever y'all give me, I can take it.
And you know you don't want to go to TJJD.
No, sir.
How long do we have before your 18th birthday?
Sir,
How long do we have before your 18th birthday?
18 months.
That's the period you are going to be under the supervision of this court.
Yes, sir.
You understand the court is not going to be talking to you every day. Who does the court talk to you through?
Yes, sir.
No, who does the court talk to you through?
You said who did they talk to me through?
During the period of your probation, the judge doesn't talk to you,
Yes,
right?
sir.
The judge talks to you through who?
My PO?
So you understand when your PO says, do this, you know that's the judge talking, right?
Yes, sir.
And understanding all that,
Yes, sir.
anytime you argue with your probation officer, you're arguing with the judge.
Yes, sir.
And you know the consequence of that.
Yes, sir.
So when you said you told your probation officer, I don't need rehab, you know, you're talking to the judge.
Yes, sir.
And when you talk to the judge that way, what do you think happens?
They gonna send me off.
Okay, no further question, Judge.
State,
I don't have any questions.
may Mr. Hood be finally excused by both sides?
Yes, Your Honor.
Yes, Your Honor.
Who would the respondent call as his next witness?
I have no further question.
All right. Rebuttal, Ms. Smith?
I don't have any.
All right. Summation.
Judge, I would just ask that you follow the stipulation that Mr. Hood has a drug assessment, that if that assessment recommends inpatient TYRC, that he be ordered to complete it. After his completion of TYRC, that he still engage in, I believe I put in the stipulation FIT program, but I meant FFT program, the program he's currently in, and that an electronic monitor also be imposed, as well as any other conditions that you see fit.
Mr. Adeniji.
Yes, Judge. Everything that's been recommended as services for Mr. Hood, I believe is in his best interest, and those are services that I believe will help him do the right thing and doesn't get to come back. And I would just urge the court to approve the agreement as signed.
State, rebuttal.
I'll waive.
Okay. before we proceed any further, the court will also take judicial notice of the contents of the court's file in cause number 323-112653-19, and the hearing over which the court personally presided in that case. In that case, back in February of this year, Mr. Hood was placed on probation by this court, and as one of the many conditions of probation, the court ordered him to complete 80 hours of community service. 40 hours of those 80 hours would be probated if Mr. Hood completed the first 40 hours by April 5th, 2020. What the court could not have foreseen back in February was that just a few weeks later, the world would shut down because of this COVID virus. I don't think that Mr. Hood deserves to be punished for failing to complete the first 40 hours of community service in this other case for circumstances beyond his control. And the court has the power to modify on the court's own motion the conditions of probation in that other case. And so, Mr. Hood.
Yes, sir.
The deadline of April 5th in that other case, I'm going to extend that on my motion until September 1st. Okay?
Yes, sir.
So if you get those 40 hours completed between now and September 1st, you won't have to do the additional 40 hours, okay?
Yes, sir.
Okay, I'm doing that for your own good in that other case. Now, in this case, we have got a great situation, and this is the kind of situation that judges hope for. We have a concerned probation officer, we have a thoughtful prosecutor, we have a conscientious attorney, we have a great, proactive, loving parent, and we got a respectful, polite respondent. Your attitude with me, Mr. Hood, has always been positive. You've always been respectful, and that goes a long way with me. And I just want to let you know I appreciate that. I also appreciate the fact that you got level 1.0 in the back, and you did so relatively quickly. The court will follow the agreement of the parties. I'm going to extend your probation until your 18th birthday. I want you to complete a substance abuse evaluation, and if the evaluation indicates, I want you to complete TYRC inpatient treatment, okay? After you get done with inpatient treatment, you're gonna come back to probation, hopefully go back home with Ms. McGilvery, and you'll be released on the EM electronic monitor, and I want you to be involved in either FIT or FFT, whichever your probation officer thinks is gonna be the best fit and the best help for you, all right?
Yes, sir.
You have any questions of me, Mr. Hood?
No, sir.
All right. Anything else from either side?
No, Your Honor.
Nothing from my side.
That'll be the order of the court. Good luck, Mr. Hood.
Thank you.
Thank you, Joe. We appreciate you.
Thank you.
So will the rehab people come get me today?
I don't know. Yeah, I'm not sure. Okay.
Wait, can I ask a question?
Yes, sir.
Will I be
We're off the record, by the way.
will I be going to rehab today?
They're going to do the substance abuse evaluation first, and then they're going to score it. And then depending on what the score is, it sounds like Ms. Gonzalez has a bed available for you today, if that's what the evaluation tells us, okay?
Yes, sir.
All right, good luck, Mr. Hood.
Thank you.
Thank you, Your Honor.
Thank you, Ms. McGilvery.
Thank you.
All right, we'll bring the chair out with you. Thank you.
Good morning, Ms. Johnson.
Morning, how are you?
Better than I deserve.
Well, that's a good thing.
All right, are we ready to go on Mr. Herrera?
I saw the prosecutor a second ago, but I don't see her now. We were having some technical issues, so she might be getting something that I sent to her on the printer.
Oh, okay, awesome.
But I don't see Mr. Herrera either.
I believe detention is getting him let's see. Remind me how old he is. Oh, wait. Here comes Miss Smith right now. She walked in the courtroom. Remind me how old Mr. Herrera is. I've forgotten. He's 14. Okay. And back on March, the case was passed for an evaluation. And Ms. Johnson, this is being broadcast on YouTube, so I'm kind of dancing around some issues. Have you gotten that evaluation back on the evaluation?
Yes, it's back.
Okay, great. And as always, the court has the authority under section 54 of the Family Code to close the hearing off if there are any sensitive things that are going to be discussed.
There probably will be.
Okay, then at the beginning of the hearing, I'll call for that request. Now, that request will be granted unless there's an objection from the state, and then I will rule on the objection.
Thank you.
Sure. And I will let you know that the objection will be denied. I believe in the open courts provision, but I also believe in protecting kids. So
I like that. I do not see the juvenile's parent.
let's go, Bernie. Would you check the halls and see, is it Jessica Moreno or Martin Herrera? Do we know who we're expecting?
Miss Marino.
Okay, check and see if Miss Moreno is in the hallway and then show her to the parent room. Okay.
I also don't see the probation officer.
Let's see. I bet Miss Turner Hill will be here shortly. Oh, Ms. Smith, are you planning on proceeding on the entirety of the petition, second amended petition in this case?
No, I'm only going forward on, I believe it's paragraph 3, the assault public servant. I will waive the criminal mischief in the family violence case.
That's your understanding, Ms. Johnson?
It is.
No, I have not. Oh, yes, I do. Let's bend the monitor down just a little bit so we can see her a little bit better. Good morning, Ms. Moreno.
Good morning.
Okay. In a little bit, I have a very long document called a Stipulation of Evidence Judicial Confession Disposition Agreement that I will have to read to Mr. Herrera. At the end and through it, I will ask him almost paragraph by paragraph if he agrees with it. At the very end, I will ask him if he agrees with the whole thing, and then I will ask you if you agree with the whole thing, okay?
Okay.
You don't have to do it now, but when we get to that part, make sure you're listening closely. And I will ask you just not paragraph by paragraph, but at the end if you agree with the whole thing, okay?
Okay.
Okay. Until then, I'm going to leave your microphone on mute, okay?
Okay.
Good morning, Ms. Turner-Hill.
Morning. I'm sorry, Your Honor. Let me call detention and see where Martin is.
All right.
In just a second. They should be bringing him up, Your Honor. I'm sorry.
Sounds good. We have 45 minutes before detention hearings start. We got plenty of time. Yes, ma'am? Yes, Ms. Marino?
Can Ms. Turner here send the link to his case manager from the Yes Waiver program?
I'm sending it now. Sorry.
Okay, thank you.
Are you
It's my
sending it?
understanding that his yes waiver representative may appear.
Yes, that's what we're waiting on her to send the link.
Oh, okay, okay.
Yes.
That's fine. Then I'll wait to start everything for her to zoom
Thank
in. All right, I've got somebody in the courtroom. I'm going to.
Did someone actually speak to her this morning? Oh,
She's on, Carmen.
All right, what's under there?
Hi, Martin.
Can you see me?
Thank you for your patience, everyone. Let's see. All right. It is Friday, May 1st, 2020. We're here at cause number 323-112618-19 in the matter of Martin Nicholas Herrera Jr. Pursuant to Rule 201 of the Texas Rules of Evidence, the court takes judicial notice of the contents of the court's file, as well as all hearings over which the court has personally previously presided. Are both sides ready to proceed?
She's on mute.
Ready.
Uh-oh,
The
Ms.
defense-
Smith, I have no audio. Oh, wait, hold on. It's on my end. Are both sides ready to proceed?
State's ready.
The respondent is ready, Your Honor. We'd also request that this hearing be closed.
All right. Pursuant to Section 54.08 of the Texas Family Code, the court finds that despite the open courts provision of the Texas Constitution, that there are sensitive matters to be discussed during this hearing, and that it is in the respondent's best interest to close this hearing to the public. So at this time, I will stop the live stream of this hearing. If I can